At the Court of Appeals in the city of Riverside, justices gathered to hear a recreation of arguments in the Brown versus Board of Education case.
235 years ago, ladies and gentlemen, this country declared its independence from England with these words, and I quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among those are life, liberty, and the pursuit of happiness." It took, ladies and gentlemen, almost 100 years after those words were written and spoken and defended with blood for our government, 16 administrations later, to stand up and to proclaim that by all men, we really meant all and not just some. And it took almost another 100 years for our judiciary to stand up and to proclaim that by equal, we really meant equal and not just separate but equal. On our nation's slow and rocky path toward universal civil rights, there have been great leaps forward. For example, the Emancipation Proclamation, the 13th Amendment abolishing slavery, the 14th Amendment defining citizenship and requiring equal protection under the law for all of its citizens, and of course the 15th Amendment guaranteeing the right to vote to all citizens. There have also been times, ladies and gentlemen, when we as a nation have stumbled and we've fallen. For example, the Dred Scott decision was one of those moments. The Jim Crow laws, the Asian Exclusion Acts, the internment of Japanese Americans during World War II, and of course, Plessy versus Ferguson, where the United States Supreme Court upheld a state's right to enact legislation requiring persons of different races to use separate but equal segregated facilities. For 60 long years, ladies and gentlemen, Plessy versus Ferguson remained the law of the land, allowing states that embraced racial segregation to maintain separate facilities for blacks and for whites, with the provision that the facilities and services be of, quote, equal caliber. It was not until 1954 that the Supreme Court would set its feet on that path to overturning Plessy versus Ferguson. That case was Brown versus Board of Education. And it was one of 5 class action suits from all over the country heard together before the United States Supreme Court, all seeking the very same relief. And that relief, ladies and gentlemen, was the desegregation of public schools. And while it would take many more years before the job was finished, Brown was the first step, the very first step, arguably the most important step in the eradication of the doctrine of equal but separate. And so, ladies and gentlemen, I say it was the most important step, not only because it was the first major victory over that pernicious doctrine, but also because it concerned that which, very simply, makes any civilization either succeed or fail.
In every major city of the United States today. It's a story that begins when the first slave ships came to the United States. It's a story that includes what occurred in Philadelphia in 1787. The framers of the Constitution institutionalized slavery in the very fabric of that doctrine. And let there be no mistake, the Constitution does institutionalize slavery. It does so in the language of Article 1, Section 9, that prevented Congress from banning the importation of slaves for 20 years. In the language of Article 5, that prohibited that provision from being altered by amendment. It's in the language of Article 1, that says that slaves will be counted only as 3/5 of persons for the purpose of apportionment. It's found so tragically in the language of Article 4, that said if a slave escaped to a free state, the slave had to be returned. Following the Civil War, of course, 3 important amendments were added to the Constitution, one of which, 14th Amendment, and the guarantee of equal protection, is what you'll be focusing on this afternoon. After the Civil War, Reconstruction happened. And for the first time, there was meaningful progress towards equality for those of African descent in the South. But all too quickly, Reconstruction ended with the election of 1876, when the Democrat Samuel Tilden beat the Republican Ruther B. Hayes in the popular vote, without enough votes in the Electoral College to triumph.
Again, may it please the Court. We are here today based on a challenge by the NAACP Legal Defense Fund made to various statutes and provisions from across the country that we contend provide for inadequate treatment of black people simply because of the color of their skin. The plaintiffs would submit that the 5 consolidated cases can best be framed by reference to the South Carolina Constitution and the South Carolina statute, as they are representative of the segregation laws at issue.
What was the provision in the South Carolina law or statute or Constitution?
And the South Carolina Constitution reads as follows: separate schools shall be provided for children of the white races, and no child of either race shall ever be permitted to attend school provided for children of the other race. And the South Carolina Code reads, it shall be unlawful for pupils of one race to attend schools provided by boards of trustees for persons of another.
Thank you very much. I've been asked to address, in a more probing fashion, some of these sociological studies and issues revolving the inherent pernicious effects of segregation. I believe a question was asked about what evidence is there with respect to the adverse effect.
My recollection is that this record, there was only one expert that testified in this record about the effects. Is that correct?
That's correct, Your Honor, but there is a compilation of other data that was provided.
Were the qualifications of that expert questioned?
I don't believe that they were genuinely questioned, and I think, Your Honor...
How credible does that make the expert, or how lacking in credibility does that make the expert, to put it a different way?
Your Honor, quite frankly, it didn't lay a finger on the expert's credibility, because you have an overwhelming majority of those in the social sciences being in complete agreement with that. I'd also like to point out, Your Honor, to the mid-century study, White House report, with respect to the pernicious effects of segregation on black children. In particular, Your Honor, and prior to doing that, I want to point out there was a reference to a finding of fact in the district court below. Your Honor, I would refer to finding of fact number 8, and this fact has been uncontroverted, which states that segregation of white and colored children in public schools has a detrimental effect upon the colored children. The impact is greater when it has the sanction of law, for the policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. A sense of inferiority affects the motivation of the child to learn. Segregation with the sanction of law, therefore, has a tendency to retard the educational and mental development of Negro children and to deprive them of some of the benefits they would receive in a racially integrated school system.
And that the 14th Amendment's aim was against discrimination because of race or color, that could apply across time to new facts, specific facts that the framers may not have envisioned. But the second point I would say is, even if this court were to look at the specific understanding of the framers and the people at the time of the 14th Amendment's ratification in 1868 as to the specific practice of integrated versus segregated schools, even then there is sufficient historical evidence we would submit for this court to reverse the doctrine of separate but equal and to grant judgment to appellants in this case. And I would say that... What
is it exactly that you're asking us to do in this case?
We are asking this court to reverse the judgment of the three-judge district court in the Kansas and all the federal cases, affirm the Delaware Supreme Court and Chancellor's judgments ordering integration, and to strike down the South Carolina statutes and the Kansas provisions, both on their face and as applied as unconstitutional. I think this court can do so.
And what do we do with Plessy versus Ferguson?
Directly. But I'd at least like to start my remarks with a statement of what this case is not about. This case is not about whether segregation is right or wrong, moral or immoral, wise or unwise. We believe we all have perceptions on those questions. And perhaps this case would be more easily resolved if it was about those things. But this case is actually about whether segregation is constitutional. And that is a very narrow question, in fact, which has two parts to the equation. One is, does the 14th Amendment, shall I say, speak directly to segregation? Or stated differently, without a question of equality, does the 14th Amendment preclude segregation? And of course, the second part of that question, if we decide no, is how do we consider the concept of equality in connection with segregation? That's something this court has done as recently as in Sweat. But let me start with the first question. Does the 14th Amendment speak directly to segregation?
For the Press Enterprise and PE.com, this is Angel Ortiz.